All persons having business before the Honourable Court are commanded to give their attendance and they shall be heard. God save the Queen. Be seated. This is the Monash University Moot Court sitting as the Victoria Court of Appeal in the matter of Stephen James Callahan and
I appear for the appellant, Your Honours, with my junior Miss Spencer.
Thank you very much.
Up here on behalf of the respondent, Your Honour, with my junior Booker.
Thank you very much. Now, Mr. McGrady, it's your go.
Thank you, Your Honour. It is my submission that the trial judge erred in directing the jury that acute stress disorder could constitute injury under Section 18 of the Crimes Act. As such, the appellant's conviction should be overturned. My submission is broken down into three parts. The first part being that on construction of Section 18 of the Crimes Act, acute stress disorder does not constitute injury. The second part of my submission is that injury has a different definition to that of actual bodily harm. And in the alternative, should the court not accept that injury and actual bodily harm have distinct definitions, an acute stress disorder does not fall within the definition of actual bodily harm in this circumstance. My junior will submit that the trial judge erred in directing the jury as to recklessness so as to constitute a substantial miscarriage of justice. Moving to my first submission, that acute stress disorder should not be taken to be injury under Section 18 of the Crimes Act. Section 15 of the Crimes Act defines injury. Injury includes unconsciousness, hysteria, pain, and any substantial impairment of bodily function. Acute stress disorder, the definition of for our purposes, from edition 4 of the Diagnostic and Statistical Manual of Mental Disorders, published by the American Psychiatric Association, at page 429, and I quote, is a condition which occurs when, and I quote, either while experiencing the traumatic event or after the event, the individual has at least three of the following dissociative symptoms: a subjective sense of numbing, detachment or absence of emotional responsiveness, a reduction of awareness of his or her surroundings, derealisation, depersonalisation, or a dissociative amnesia. Following the trauma, the traumatic event is persistently re-experienced, and the individual displays marked avoidance of stimuli that may arouse recollections of the trauma, and has marked symptoms of anxiety or increased arousal. The symptoms may cause clinically significant distress, significantly interfere with normal functioning, or impair the individual's ability to pursue necessary tasks. It is my submission that acute stress disorder does not fall under the definition of injury. Further to that, it is my submission that it does not fall within the definition of impairment of bodily harm, pain or hysteria, and it should not be included in the definition. Acute stress disorder does not fall under the definition of impairment of bodily function because mental and physical injury are distinct. I rely upon the case of Humphreys and Poljak, reported in 1992 in Volume 2 of the Victorian Reports at page 121.
It comes from a very different statutory regime,
It does, Your Honour.
which provides a definition of serious injury in both the physical component and the medical component.
Yes, Your Honour. Under the Transport Accident Act of 1986, Section 93(17) has three subsections, A, B and C. A being serious long-term impairment or loss of bodily function, or B, permanent serious disfigurement, or C, severe long-term mental or severe long-term behavioural disturbance or disorder. And D, the fetus, Your Honour. It is my submission that as the court found in Humphreys that impairment of the person is not the same as impairment of bodily function, on the basis that impairment of mental function, impairment of bodily function should be addressed under subsection A can be parallel to the definition of injury, and that any mental disturbances should be addressed under the definition of hysteria.
Yeah, I reckon that was because they were trying to interpret the statute which defines serious injury, both as including on the one hand a long-term impairment of bodily function, and on the other hand severe mental disturbance or disorder. And they were trying to work out why it was at the legal stage which provided the definition of those two things. It's a bit different from section 15 of the Crime Act.
It certainly is different, Your Honour, but my argument is one of analogy in that the same principles should be applied, because we have an express mention of impairment of bodily function, whilst at the same time we have an express mention of hysteria, which is a mental condition.
One of the things worrying a bit about it, Mr. Brady, is that section 19, I think it was subsection 19 of section 93 of the Transport Act says a serious injury means. Section 15, I think, of the Crime Act says it doesn't include. It's inclusive.
Certainly, Your Honour.
The question really is whether you can include within the definition of injury the psychiatric injuries distinct from the physical.
Your Honour, it is my submission that you cannot, and moving to that point of the definition being an inclusive definition, it is my submission that based upon the introduction of sections 21 and 21A in the 1994 amendment, it is not the intention of the Parliament to include psychiatric injury or psychiatric harm as injury under section 18.
What about hysteria? What's hysteria?
Your Honour, hysteria in itself has both a technical and a popular meaning, and it is my submission that hysteria should be read on its technical meaning. As such, acute stress disorder would not fall under that meaning.
It's not physical.
No, it's not, Your Honour. However, it's my submission that a situation such as the one at hand, being one of acute stress disorder, does not fall under that section.
Psychologically, an hysterical reaction is indeed a mental reaction. If you're going to take the technical meaning of it, a person might suffer a minor physical injury, but then lose the loss of his arm or the loss of the use of his arm through an hysterical condition.
Technically, Your Honour, is yes, and it's my submission that although that has or deals with psychological harm, it doesn't make provision for the psychological condition of acute stress disorder in doing so. Now, section 21 and 21A were introduced to cover threats to cause injury, and section 21A was the stalking legislation. Now, between those two sections, they mention putting a person in fear due to threat, as well as mental harm. Now, it's my submission that those sections and section 18 should be read differently, and the Latin maxim expressio unus est exclusio uterius should apply, being that the expression of mental harm and fear in sections 21 and 21A is to the exclusion of those elements in the definition of injury, section 18. Now, drawing upon Hussain against the Under-Secretary of Industrial Relations and Technology of New South Wales, decided in 1982 and reported in volume 148 of the Commonwealth Law Reports at page 88, the maxim can be used, and I quote page 94, it applies when the intention it expresses is discoverable on the face of the instrument. It's my submission that the intention to exclude mental harm and fear from the definition of injury is discoverable on the face of the crime date. Now, that is because apprehension, fear and mental harm are all expressly mentioned in sections 21 and 21A, which have followed, or which has been a later amendment to the Crimes Act than the 1985 amendment, which included sections 15 through 18. Now, in the alternative, should the court not accept that that maximum should be applied, then it's my submission that the Parliament had similar situations to ours in mind, and the Parliament has chosen not to include protection against mental harm or psychological harm, besides that the allowance made for hysteria under section 18.
What do you say hysteria means?
Drawing upon the definition from Schmidt's Attorney's Dictionary of Medicine, which is marked in 1.1.4 for your honour's attention, the technical definition is a type of mental condition, technically a psychoneurosis, in which exaggerated emotions become transformed into physical manifestations as overactive or perverted sense impressions. Reading that on its technical meaning would preclude acute stress disorder from falling into it, because acute stress disorder is a depressive disorder, whereas hysteria is a psychoneurosis, which are quite distinct mental problems.
So the difference is that acute stress disorder doesn't convert itself into physical manifestation, but all of the injury remains mental or psychological.
Acute stress disorder may develop into some physical symptoms. However, they are symptoms which do not constitute injury. It's my submission they do not constitute injury, such as sleeplessness and a reluctance to go back to a place of trauma. Whereas hysteria itself has a greater physical impact upon the human body so as to create medical conditions of it.
You concede that a psychiatric condition can constitute an injury in normal parlance?
Your Honour, it is my submission that it possibly could. However, here, the section which we are discussing, being section 18, should not be read as a matter of normal parliament.
But wouldn't you say that injury in common speech doesn't include psychological injury, contrary to the learned presiding judge's suggestion?
So, Your Honour, is Your Honour saying that...
Why are you not submitting that in common speech, injury does not include psychological injury? Or do you accept it does?
It's my submission that even should injury in common speech, should psychological harm even in common speech constitute injury, then that is not definitive of psychological harm constituting injury under section 18 as it is.
It's that that's causing me the problem, because the definition is an inclusive definition, and it includes this hysteria, which has an impact on the psyche.
Certainly, Your Honour. And it's my submission that that is the only provision which the Parliament has sought to make for hysteria on its technical meaning. And as I've already submitted, mental harm, which acute stress disorder may fall under, has been provided for in section 21A, which is the stalking legislation. And it's not, therefore, the intention of the Parliament to include mental harm under hysteria. Now, I draw upon the second reading speech of the Honourable Member from Melbourne, Mr Cole, in the Legislative Assembly from volume 421 of the Parliamentary Debates.
Should we both look at that?
Certainly, Your Honour, you can find it at 1.1.5.
Are we entitled to look at what people have said in Parliament in interpreting the statute?
certainly, Your Honour, you are, that the court is able to consider exterior evidence in interpreting this legislation.
For what purpose do you say?
I might take a moment to consult with you, Your Honour. Your Honour, it's my submission that as the definition in section 15 for application to section 18 is not plain in its meaning, the court should have recourse to the parliamentary debate.
To resolve any ambiguity, you say?
That's correct, Your Honour.
Now, what do you want to tell us about the second reading speech?
This is the second reading speech from the introduction of the stalking legislation in 1994, and I quote the Honourable Member from Melbourne. The crucial point is that the offence of stalking fills the gap, and by creating an offence, it removes the difficulties and doubt associated with charging a person with other offences. It is my submission that the gap which the Honourable Member from Melbourne speaks about is similar to the situation in which we find ourselves here, and the Parliament has essentially sought to close that gap with the stalking legislation and not in our situation. And as such, acute stress disorder does not constitute injury under section 18.
Why do you say that that's so? The section which deals with the effect on a person, an act of another, is different from a stalking type of situation. We're really concerned about people being followed and convenience in that sense. Policy behind the section that deals with someone acting so as to affect another person is different from that.
Your Honour, it's my submission that given the facts of our case, that the appellant had a crush on the victim and affected her in a mental fashion. It's a very similar scenario to the type of scenario which stalking legislation was enacted to cover.
Seems to be an odd way to try and track the
Yes, Your Honour, it is an odd way, and it's my submission. It's my submission that whilst the action may have been ill-conceived, it was certainly flirtatious and it was a joke. There was no menace involved. If I might move to the second part of my submission, and that is that injury should be interpreted differently to actual bodily harm. Now, that submission is based, and I'll be brief as I'm running out of time, Your Honours, that submission is based upon the notion that when the Parliament enacted the 1985 amendment, it was to do so to encourage a simplification of the law and amend it altogether. The reason, and I seek to rely, Your Honours, on the fact that the Parliament has included the word injury rather than actual bodily harm, and it's my submission that they are two distinct concepts. Now, should the court not accept that submission, then it is my alternative submission that acute stress disorder does not fall within the meaning of actual bodily harm, as has been interpreted from the 1861 English Offences Against the Person Act.
Repeating yourself, you wouldn't have to argue too hard to convince me.
In concluding, then, Your Honours, it is my submission that acute stress disorder does not fall within any of the subcategories of the definition of injury as laid out in section 15. It is my further submission that it is not the intention of the Parliament for acute stress disorder to be included as an injury under the definition of section 15 for the purposes of section 18. Now, should the court have accepted the first part of my submission that on construction of the Crimes Act acute stress disorder does not constitute injury, then it need not accept either the second or the third parts. Should the court not accept the first part of my submission, for the submission to succeed, the court must accept either that actual bodily harm and injury have distinct definitions, or failing that, acute stress disorder does not fall within the definition of actual bodily harm in this circumstance. It is therefore my submission the appellant's conviction should be overturned on the basis that acute stress disorder does not constitute injury for the purpose of Section 18. In the alternative, the appellant submits that the trial judge erred in directing the jury as to recklessness, and that alternative submission will be put by my junior.
Well, if we accept your submission and the proper meaning of injury, what should we do with this? We send it back for re-trial, or do we enter a verdict of acquittal?
Your Honour, it is my submission that a verdict of acquittal should be entered on the basis that the requisite elements of the offence are not made out.
Thanks very much, Mr. Kenny. Yes, Spencer.
Your Honours, I have a single submission this evening that the learned trial judge erred when directing the jury that in deciding whether the appellant acted recklessly, that they need only be satisfied that the appellant foresaw injury might result from his actions. Now, the correct test that should have been applied here is that injury must be foreseen as a probable and not merely possible consequence of the accused actions. Now, this test has been put forward in regard to Section 18 in the case of the Queen against Toberton and Dale, which is an unreported judgment of the Victorian Court of Appeal, number 263, 1995. Now, that case has also been cited with approval by Justice Mandy in the case of Metamuri against Cheeseman, reported in 1998 in Volume 4 of the Victorian Reports at page 484. Further to this being the accepted meaning for recklessness with regards to Section 18, which was the section in question in the case of the Queen against Toberton and Dale, as previously cited. This can also be supported as the correct definition for recklessness with regards to a number of other related offences. The first of these is serious injury, which is Section 17 of the Crimes Act. That section provides for recklessly causing serious injury as opposed to injury under Section 18. The leading case on this section is the case of the Queen and Campbell. And that case was reported in 1997 in Volume 2 of the Victorian Reports at 585. Chief Justice Phillips and Justices Hayne and Crockett all agreed in this case that the trial judge had misdirected the jury by telling them that recklessness only involved a test of possibility. The three justices also said in this case that the appropriate test was one of foresight that injury would probably result. Further to this, we can look at the cases of reckless endangerment. Reckless endangerment is set out in sections 22 and 23 of the Crimes Act. The difference there being section 22 is danger of death, section 23 is danger of serious injury. These cases are all quite similar to section 18 in that they were all introduced into the Crimes Act by the 91 Amendment. The leading case with regards to reckless endangerment is the case of the Queen against Newry, reported in 1990 in the Victorian Report, at page 641. Again, the test here is that recklessness is the disregard of foreseen probable consequences.
What does probable mean here? Say you take a 6-shooter and there's a revolver and there's only one cartridge and you spin it and put it to your loved one's head and pull the trigger. Is that dangerous, although the chance it might be said to be 1 in 6? Is that probable?
Well, the definition of probable, Your Honour, can be found in the High Court decision of the Queen against Crabb, and that was decided in 1985 and reported in volume 156 of the Commonwealth Law Report, page 464. And at page 469, a unanimous decision of the court said that probable means likely to happen. So, in your example, the accused would have had to foreseen at the time that as a result of his pulling the trigger, it was likely, or more than likely, that serious injury or death, depending on which offence is being charged with, would result to the victim. It's a subjective test we're looking at, so we're trying to look at whether or not the accused foresaw this would or would not happen.
Is it something you can do on a mathematical basis, or do you just look at the facts involved and say, well, if he turned his brain a little, he must have foreseen that was a probable result?
Well, certainly the reasonableness of the situation can go to whether or not the accused held that plan. But it is the subjective intent, or recklessness, intent if you like, of the party that is an issue. So to put a mathematical figure on it and saying that it must be more than 50% or less than 50% is not really a good statement of the test that should be applied.
So what do you say is the right test? That it might probably result?
No, that it will, or that is likely to result. Might would,
What's might?
might has been used in the cases that refer to a test of possibility. So might connotes the same ideas as a possibility test. With a probability test, we're using concepts such as likely, or it will happen, or it is very likely to happen.
Well, it will happen, that takes it beyond...
Well, it will happen, it's probably up to a level of intent, Your Honour. As long as the intent
That suggests a certainty, doesn't it?
certainly, Your Honour, consider making a mistake.
Only a little one. Come back to probability then. What do you say is the use of probability?
Likely tends to be the word that's used, Your Honour, and that's certainly the word that is used in the case of the Queen against Crabb, and also Queen against Newry and Queen against Campbell. The words likely have been used.
But it's not more likely than not.
More likely than not.
Is that all right? Do you accept that?
Well, that would almost imply a test of more than 50%, and getting back to this idea.
Tell juries that the standard of proof, for example, on the balance of probabilities in civil case is more likely than not. You say this for a different concept, do you?
This is a concept that the accused must foresee because of the likely consequences of his actions. So the accused must do the act knowing that it is likely that this will occur. So
You can't really have a mathematical formula test, I don't think. I think it's really a matter of common sense more than foreseeing the probable consequences of your conduct. And then going ahead with indifference to those consequences.
certainly, Your Honour, that's almost an exact restatement of the test in the Queen and Crabb.
Yeah. In the example that Mr. Justice Brookie gave about the fixed ship, one bullet, Russian bullet, it'd be pretty hard to deny that if you put that to your loved one's head, you must foresee as a probable consequence that the gun could go off.
Well, really, Your Honour, that's a question for the jury to decide.
Yeah, exactly.
They can say, well, maybe it's only a possible consequence, maybe it's a probable consequence. The High Court, in the case of Crabb, has said that there's a very distinct difference between something that's possible, because if I walk across the road, it's possible that I'm going to get run over.
Yeah.
But if I walk across the road, it's probably not probable that I'll get run over unless I'm going to stand there and wait for a car to hit me.
So we don't want to define too closely the word probable in those circumstances.
Certainly not, Your Honour, because it has a common meaning which I would submit that juries understand. It's a word that's in everyday use.
Justice Brooking referring to
household going against a loved one, care, playing a love game.
Certainly I have read other judgments that have been very similar circumstances. If I may move now to the last part of my submission, that further that as a matter of statutory interpretation, Section 18 must have the same definition of recklessness as the other like sections in the Act.
Certainly Section 7.
Certainly Section 17, Your Honour, but I would also submit Sections 22 and 23, reckless endangerment.
They might be slightly different, yeah. They have different factors.
They're different. There's a slightly different test there, Your Honour, in that reckless endangerment requires an objective and a subjective test.
You don't need that in these two sections, do you? Section 7 and Section 18.
No, you don't, Your Honour, but the objective test in the reckless endangerment cases goes to the concept of danger rather than the concept of recklessness. So the subjective test in Sections 22 and 23 must therefore, I would submit, be the same as in Sections 17 and 18. Now,
Say again, we're against you on the point which Bernard Leader has argued, and we say that this was injury, but we uphold your submission and say there was misdirection about this. What do we do?
well, Your Honour,
Quash the conviction, but do we order a retrial or do we correct a verdict of acquittal?
I would submit, Your Honour, that you order a retrial.
So the jury would be properly directed.
Certainly, and the case can be decided with regard to the proper law on the subject.
Yes.
Now, in the case of the Queen against Campbell, the court said that these group of sections in the Crimes Act was in fact a group. They were kindred sections, is the term they used. And a quote from page 593,
Campbell's case.
Campbell's case. Where's that folder? Just. It will be under tab 1.2, at the bottom there.
593, did you say?
593, Your Honour. And I'm quoting from paragraph 15.
Yeah.
That it cannot be supposed that the legislature intended that there be, or that the courts would interpret the relevant sections so as to produce a different requirement concerning the intent with regard to each of these sections. So I would submit that that supports my submission, that all these sections must be interpreted in a like manner. Also, as a matter of practical reality,
If this was the case that was on the kindred section, the one of your clients was charged under, in respect to that, the direction was almost exactly the same as the one given here, so you can argue heavily.
very heavily, Your Honour, and also on the case, the unreported case, the Queen against Clover and Dale, where there was again a very similar misdirection and the court found in favour of the appellant. Finally, as a matter of practical reality, all these sections need to be interpreted in a like manner. Often an accused is charged with Section 17, Section 18 as an alternative offence if the jury doesn't find that the injury is a serious one, and Section 22 or 23 that there was a form of endangerment. And many of the cases, these are all alternative or additional charges. Now, in a case, if all of these charges have been laid, explaining to a jury that under one section recklessness means this and on the next charge recklessness means that is going to be very, very confusing. And this is similar again to what happened in the Queen against Campbell, where the original direction by the trial judge was actually correct, but there was a later direction made that was incorrect. And that was found to be a misdirection that was going to be very confusing for the jury.
Well, it's not just confusing, it would create a sense of fundamental unfairness, wouldn't it?
Certainly.
That depending on which section a person was charged, there would be a different definition of reckless, which would be either a harder or an easier test to satisfy, depending on which one it was.
Especially considering, Your Honour, that Section 18 is often the alternative charge to Section 17, so the only differentiating factor there being the degree of harm caused to the victim. And it would be, I would suggest, manifestly unfair to have a different standard of recklessness on those two sections.
What do you say is more important, the manifest unfairness of that or the risk of confusion?
I would submit that the manifest unfairness results from the risk of confusion. Because of the risk of confusion, the jury may convict upon something that they don't quite on the law that, as they understand it, which is an incorrect understanding of the way it should be interpreted.
What is it that stops a person from being charged and convicted for failure of offence to carry 5 years? If you know in the back of your mind that your workmate has been subjected to trauma in the form of being held up at some earlier stage, and actually come in without a protection, you say, boom, and she falls into a heap on the floor.
Well, yeah, I direct you. Certainly, Your Honour, and I'd also direct your attention to the fact that the accused or the appellant only knew that she'd suffered some trauma at work and wasn't aware of the nature of that trauma. So he knew that the victim had suffered some trauma at work. He was fairly young, naive, infatuated with the victim, has then played a misconceived practical joke on her and attempted a flirtation, and then he could be sent to prison for 5 years as a ridiculous situation. And it would be
Without lawful excuse in the section.
So,
What's without lawful excuse in the section?
well, there are a number of recognised lawful excuses.
Is it only self-defence or much wider?
Well, I'd considered,
Consent?
sorry, Your Honour, I'd considered making a submission that the lawful excuse in this case was under the case of Collins and Woolcock. I'm not sure of the citation, which allows for the everyday interactions or the everyday intercourse.
Bit of play fun with the workmates.
And I'd almost thought that perhaps I could make a submission that a bit of flirtation was necessary for the conduct of everyday life, but I thought you may laugh at me, so... I didn't go that far.
It's a romance form of flirtation.
It's probably...
I'm speaking for myself, I'm not sure that my brother is necessarily
Your Honour, I'd agree with you that it is probably a pretty Neanderthal form of flirtation, but it's probably
what's the
pretty
reason?
common.
You thought that you'd leap into his arms and be eternally grateful or something?
Quite possibly, but probably that's not a question this court has to answer, so we're just looking at...
I just wondered how we reconcile the section with the sort of example that I gave to you, that's all, because if we're going to carry it to those lengths, we're going to have a lot of people in jail.
Certainly, Your Honour, I absolutely agree with that. But this is a ridiculous act to be bringing an indictable offence against a person for playing a practical joke. A more appropriate action, if you like, for this would perhaps be under the law of torts, where the victim could sue the appellant for her damage and perhaps recover the cost of the medical expenses. This is hardly criminal behaviour, and it's not appropriate that it's be treated as such.
How does that sit with workplace bullying examples? Of which there have been many spoken about in the media recently.
Certainly, and a lot of the workplace bullying examples that I'm aware of have actually been quite violent.
But they're often described as practical jokes, aren't they?
Setting somebody on fire, which is one that I'm aware of, or locking them, beating them and locking them in a room, or I can't remember some of the other ones that I'm aware of, but
Pretending to hold up a back teller is a seriously misconceived practical joke. It's not, as I would say, innocent flirtation. And a practical joke, I think, is probably diminishing or demeaning what it really is.
I would submit that this case can almost be compared to coming up behind a friend and placing your hands over their eyes or grabbing them around the waist to give them a little fright.
But that's different for a bank teller, isn't it? Because it is a risk of employment with the bank teller that they'll be held up, as it is with a service station attendant or the like.
Yes, Your Honour.
And so a practical joke, I'm just concerned about that. If setting fire to somebody in a toilet in a workplace would be seen to be criminal, not tortious, what's the difference between that and pretending to hold up a bank teller?
Well, probably here we come back to this issue of the harm suffered and whether or not it's physical or mental injury, as put by my learned leader. But also, the intent behind the act is somewhat different. In setting somebody on fire, you can foresee that they are going to be injured. That just the mere fact of having fire near a human body, you're going to get burnt. But in this case, all he expected was a little fright.
Well, I wonder why you can see it so readily, Mr. Justice Brooking, if we upheld your point about misdirection, should go back to retrial. Or would you say that if the judge had read the jury properly in the court, would have inevitably resulted from a verdict?
Well, I made that submission on the basis that it's a question for the jury to decide.
Having been asked to do their job properly.
And having been able to do their job properly, personally, I don't think that it is reckless behaviour, relevantly reckless behaviour, but I can't speak for the majority of citizens. And I feel that my time is up, so I'll just make a quick summation. That if you accept my learned leader's submissions that either injury on construction is not equal to mental harm, or alternatively that injury is not actual bodily harm, or alternatively that acute stress disorder is not actual bodily harm, then we would call on the court to acquit the account. Consequently, if you choose to accept my submission that recklessness is foresight of consequences and hence there was a serious misdirection in the trial here at hand, then either a retrial should be ordered or, if your honours think it appropriate, an acquittal of the accused. And that could be
Yes, Mr. Mayor.
Your Honours, I'll be dealing with the appellant's first submission, second submission, in relation to recklessness, and my junior counsel shall be responding to their first in relation to injury. Appellants have made reference to the court of Tottenham, which relied on the decision of Newry, reported in 1990 Victorian Law Reports at 641. We submit that if the learned trial judge was bound by Tottenham, by Newry, and therefore Tottenham, that he ought to have followed Newry and Tottenham. However, we submit that Newry ought to be reconsidered and overturned, and therefore, in accordance with Section 568 of the Crimes Act, this ground of appeal should be dismissed as there has been no substantial miscarriage of justice.
There's a bit of a problem about that, I suppose, that Newry was a fairly recent decision. Tottenham is a more recent decision. And then when they Campbell on top of that, which is even closer to home.
Your Honour, we believe that the court erred in its decision in Newry, and this is subsequently just been applied to each
That other cause main has been of error.
Yes. So therefore we need to go back to Newry and address the error there. And in doing that, we'll be able to find that Tottenham should also not be followed. In the alternative to this argument, we submit that if the court affirms Newry, that the decision in Newry does not applied to Section 18 of the Crimes Act 1958. I'd now like to move back to my first submission. So the leading case in this area is the Queen against Newry. In the Queen against Newry, at page 643, reference is made to the decision in the Queen and Campbell, reported in, the Queen and Crab, reported in 1985, volume 156 of the Commonwealth Law Reports, at 465. In Newry, there is no real discussion on the decision in the Queen and Crab. It's almost been taken for granted that the court is bound by that decision. If we actually go to the Queen and Crab, it was a case dealing specifically with murder and only made a binding ratio in relation to murder. It made no mention of any other offence other than that of murder. We submit that this definitely did not bind the Supreme Court and that they should have followed the decision in the Queen and against Kane, reported in 1974, Victorian Reports at 759. That case was in relation to an offence prior to the amendment in 1985.
Malicious wounding.
Yeah, that being a malicious wounding. We would submit that this offence is a lot more analogous to the crime we have here than murder. The Supreme Court in Newry was not bound by the Queen against Crab, and they should have referred to the decision in the Queen against Newry, in the Queen against Kane, in deciding what the test for recklessness should be in relation to Section 22, that of endangering life. This has been addressed in New South Wales in the Queen against Coleman reported in 1990, volume 19 of the New South Wales Law Reports at 467. Queen against Coleman, again, was dealing with malicious wounding and the effect that the decision the Queen against Crab had on him. If you turn to page 470, the Queen against Coleman, it states that at the time of the decision in the Queen against Crab, it was generally acceptable in Australia in statutory offences other than murder, the degree of recklessness required in order to establish that an act was done maliciously was a realisation on part of the accused that a particular kind of harm in fact done might be inflicted, yet went ahead and acted. In the Queen against Coleman, they found they were definitely not bound by the decision in the Queen against Crab, and decided the decision in the Queen against Kane, which was later applied in the Queen against Lovett in 1975, Victorian Reports at 488, should be followed and was the generally accepted law in Australia at that time. Prior to the change in 1985, the state of affairs in Victoria was that in relation to murder, the foreseeability test was that of a probable, and in relation to all other statutory offences, it was a possibility. We feel that the Queen against Crab in no way affected this balance. It merely stated that in cases of murder, probable should be the test, which had no effect on any other offence, any other statutory offences. So therefore, the Supreme Court, in the decision in Newry, should have followed the previous decision of the Supreme Court in the Queen and Kane, that being the test as one of possibility rather than probable. Further to this, if we turn to the second reading speech, which is included in the folder, of the Minister for Police and Emergency Services in Parliamentary Debates, Assembly, Volume. So that volume 379 at page 1040.
Where are they involved?
That would be in part 2, Your Honour. At page 1040, the Minister for Police and Emergency Services stated that in relation to sections 15 to 18, the amendment was to simplify the offences from the previous pre-1985 Act, and in relation to recklessness, it was defined as one who does so recklessly, being aware that injury might result but goes ahead anyway. The Minister has used the word might. Prior to 1985, there was no question that might or possibility should be the term used. Crab only applied to murder. This has been affirmed in the Queen and Colony, New South Wales. They have further held that in all other offences, possibility should still be the test. We submit that Newry should be reconsidered and overruled.
Crab overruled La Fontaine.
It does.
And what was the relationship between the La Fontaine test and the statutory offences?
Prior to Crab, there had been some confusion in the High Court as to the test. Various justices had gone from possible and probable. The balance of the High Court was the probability test in relation to murder.
This was before Crab.
Yeah, prior to Crab, yes. And in Crab, it was held that the balance of the High Court had been in favour of the probability test in relation to murder, and therefore it should be followed.
Did the High Court say anything that would indicate it was limiting the definition to murder?
It certainly did, Your Honour. We turn to
When dealing with La Fontaine.
when dealing with
Yes.
what the High Court said in Crab was at 469, it should be now regarded as settled law in Australia if no statutory provision affects the position that a person who, without lawful justification or excuse, does an act knowing that it is probable that death or grievous bodily harm will result is guilty of murder. It is not enough to say that he does the act knowing that it might be possible, but not likely that death or grievous bodily harm will occur. The honours there only talk about murder. Previously they had mentioned La Fontaine and Pemble in relation to the confusion within the High Court. Within the actual ratio, the only mention is that towards murder. It makes no other mention of any other statutory provisions. Your Honours.
What's the timing between the decision of the High Court in Crab and the introduction of the crimes offence against persons provisions? You read us, the second reading speech.
Yes. Crab was reported in 1985, and the amendment came in 1985.
So do you know whether the Minister at the time of making the second reading speech was aware of the decision of the High Court in Crab?
Your Honour, I can't be sure what the Minister was aware of.
It's probably always the case.
But I would take the view that the Minister was probably relying on the previous Victorian decision in R and Kane, in the Queen against Kane, and the subsequent decisions which had followed in the Queen against Lovett.
Where we had a distinction between probability as the test and recklessness for murder and possibility as the test and recklessness for murder.
That's correct, Your Honour. As I said again, we'll submit that the Queen against Crab did not affect this position, or should not have affected this position, other than for the decision in the Queen against the River. It did not make any express or implied mention to any other statutory offence other than that of murder.
What's the principle which you follow in deciding whether to overrule its own previous decisions?
We'll submit that there's a presumption that the court should generally not overrule its previous decisions, except in cases where it would be unjust not to do so, or where there's been an obvious error in law. And I feel this case fits those criteria.
Hasn't the High Court said recently on a number of occasions that intermediate appellate courts should be more ready to overturn their previous decisions than perhaps in the past, given the strictness of the special rule met for getting cases up to the High Court?
Thank you very well.
If that were a case, that would be a helpful submission.
That would be very advantageous to our submission. And I thank you for drawing my attention to that. And if I could re-answer your question, I think that the High Court has stated that the Supreme Court should overturn rates more readily.
The problem that I have that all these matters were really referred to in Campbell's case.
Yes, Your Honour. Campbell, in the judgment of Campbell, they did make mention of the Minister's second reading speech in reference to what the counsel for the respondent, in reference to what the counsel for the respondent had raised. They didn't really address whether that was relevant or irrelevant. They mentioned it in passing, and that was about all.
The minister's reading,
Yes.
I should imagine I would put it in one side.
That's almost what they did. They didn't really address why.
It's an odd thing, that in recent years, we've even been referred to these parliamentary speeches.
We have, Your Honour. But in accordance with Section 35 of the Interpretation of Legislation Act, I feel that the court is bound in situations of ambiguity to refer to the Minister's second reading speech and other like materials.
In the case of desperation or difficulty, counsel often takes the second reading speech before the act.
No, Your Honour, I definitely wouldn't say that the second reading speech should be taken as the law, but it should definitely be taken into consideration, careful consideration, when looking at an ambiguity in an act.
Most of the acts that we find real ambiguities, then we find nothing in the second reading speech.
Yeah, I think we're blessed.
My concern is with the combination of the words might and probability. And when you consider that something might be probable,
I think the... Okay, question.
you said to me, I might probably come to dinner to your place. I have to agree with you.
Then you would need to change your mind, possibly.
Might be possible.
Yes. If I can move on to my second submission, Your Honours. We submit that Section 18 of the Crimes Act should be distinguished from Section 17, 22 and 23. When you look at Sections 17, 22 and 23, they all carry quite severe penalties, up to 15 years imprisonment. It's 15 years imprisonment for Section 17 that are recklessly causing serious injury. Would submit
How much the recklessly causing serious?
level 4, 15 years maximum.
I thought it was something else. That was intentionally causing serious. Oh, that was not 25.
Causing serious injury recklessly, level 4, 15 years maximum. That was altered in the previous years. Our offence here carries a lot, only a 5-year sentence.
The words are almost the same. Recklessly causing injury, recklessly causing serious injury. If the Order of Parliament intended to have the word recklessly meaning something different,
It would be Your Honour, there is a presumption that words within an act, particularly a part of an act, should be read in the same way. Would submit, in certain circumstances, this can be rebutted when it would be unjust or not necessarily improbable, but improbable that Parliament would have wanted that. If, again, going back to the Minister's second reading speech, he used the word might, which expressly suggests that recklessly in section 18 should be mined. Further to this, they all carry very, very high penalties and the rest are quite heinous crimes. Would submit that section 18, with its relatively minor period of imprisonment, the prosecution should not be required to show probable, but rather a lesser possibility.
Are you saying that because it's a lesser penalty, and 5 years imprisonment is a maximum is a substantial period of time for anybody to serve, but are you saying because it's a lesser term of imprisonment, therefore you can have a lower test, although the words are the same in recklessly caused serious injury and recklessly caused injury?
Yes, Your Honour.
The length of the term of imprisonment will determine what recklessness means.
Not directly, but it can suggest Parliament's intention was otherwise. I'm not saying every time there's an offence and it's got 20 years it should be probable, there's only 5 years it should be possible, but it can help us understand Parliament's intention.
Isn't that the sort of bring the law into disrepute? And would there be a risk of juries deciding that what otherwise should be serious injury they reduce to injury? In other words, verdicts that aren't true verdicts.
The difficulty is that the person charged with causing serious injury, it's an alternative, isn't it, recklessly causing injury?
It is an alternative.
Well, you wouldn't want to have a physical test, would you? It's pretty awkward to explain to the jury.
It would be awkward.
But that's what judges are there for.
They are.
Hey,
Perhaps this brings us back to the Queen and Newry. Section 17 has been defined in subsequent cases following the Queen and Newry, which applied probable test.
I don't think they did follow it. You better go and talk to Mr. Justice Hayne about this because he's next door. But I feel a bit of sympathy for it because the Crown conceded that the relevant test in the circumstances was to direct the jury as to foresee that the injury would probably occur. Now, I suppose that the Crown having conceded it, the applicant having insisted upon it, the court having looked at it all, came to the view that that was the proper test to apply. Now, it didn't seem to me that it was simply following Newry's.
In what case is this, Your Honour?
This is in Campbell's case.
In Campbell?
Which is the most recent of these.
I would agree that you go to Newry, there's a law applied. But I feel that they were very, very strongly persuaded by Newry, which was, we would submit an error in law. Your Honour, I have to wrap up my submission. Time's against me. But wrapping up again, I'd just like to say that we submit that Newry was an error and therefore should not have been followed in Totterman. And in accordance with this, there was no miscarriage of justice. And the alternative, we submit that if the court affirms Newry, that the decision in Newry does not apply to Section 18 of the Crimes Act 1958.
Thank you very much.
Justice stated to the jury that should they accept the expert evidence of acute stress disorder, then that disorder could constitute injury in in relation to Section 18 of the Crimes Act. It is our submission, Your Honours, that the trial judge did not err in this statement to the jury and that the appellant's conviction should be upheld. I have 3 submissions on this point. The first being that it was held by this court quite recently in 1998 that while Section 15 was a specific definition for injury for the purposes of the Crimes Act, that definition could be enhanced.
What do you mean by enhanced?
Enhanced in that it can be given, I will go into it in my first submission, Your Honour, but
It can be given a broader interpretation.
certainly, Your Honour, yes.
Inclusive.
Yes, yes. Your Honour, Justice Brooking stated that it was an inclusive definition and that would include an ordinary layman's interpretation of the meaning. My second submission is in relation to Parliament's intention of including mental injury within the Section 15 definition of injury due to the inclusion of hysteria. And my third submission on this point has 2 parts. The first being that Parliament sought to distinguish injury from actual bodily harm, which is probably the closest related provision in other jurisdictions. I'll then go on to look at the previous provision held in the Victorian Crimes Act. In the alternative, that this court does not accept our submissions that acute stress disorder does constitute injury for the purposes of Section 18 of the Crimes Act, we submit that in fact she was hysterical as a result of the appellant's reckless actions, and therefore, while the trial judge did err, there was no substantial miscarriage of justice under Section 568 of the Crimes Act.
And would the jury have to decide whether she was hysterical? Can we say as a matter of law that she was? No?
Certainly, Your Honour, if the court does not accept my previous submissions, that perhaps would suggest a retrial in this case.
You wouldn't say that the so claimed that one view could be taken on the question of fact, namely hysteria?
Yes, Your Honour. Yes. If I may move to my first submission, Your Honour, I submit that Section 15 of the Crimes Act and its definition of injury can be enhanced to include other forms of mental injury, and I refer to Your Honour's Justice Brooking's judgment in the Queen against Massey, which was reported in 1998 in a legal neutral citation on page 82. In that case, Your Honour, Justice Brooking referred to injury being specifically defined to include unconsciousness, hysteria, pain, and any substantial impairment of bodily function, clearly referenced to the definition under Section 15. However, Your Honour, Justice Brooking went on to say, and I quote, "It also includes, of course, the things which an ordinary layman would call an injury." And we submit in this case, Your Honour, that an ordinary layman would define mental injury within the ambit of the definition of injury. An ordinary person would assume that a psychiatric illness can also be injury.
Well, pain is really produced by the mind, isn't it?
Yes, Your Honour.
That's not a physical injury. Pain is something which is produced by the brain, I think. That's what you feel.
Yes.
And unconsciousness is the same.
However, we submit that mental illness is also contained within the brain. It is illness of the brain, and as a result, they all stem from the same cause.
Is there a difference between a true disease of the brain or a psychiatric disorder?
Between those two, Your Honour?
You say they're all comprehended by the definition, inclusive definition of injury.
We do, Your Honour. While they may be separate things, we submit that they are both included within the definition.
What do you say about psychological pain being as acute as pain of physiological origin?
We submit, Your Honour, that as one person may feel physical pain, another may feel just as greatly psychological pain, and that while an ordinary person may go to one type of doctor for a physical pain, it is widely accepted now that if you have a mental illness or psychological pain, you can also go to a doctor to have that diagnosed and treated. And if I may move on to my second submission, Your Honours, that being that Parliament intended to include mental diseases within the inclusive definition in Section 15 of the Crimes Act. Hysteria has been included in the definition, and we therefore submit that that inclusion is an indication of Parliament's intention to include mental injury within that definition. We furthermore submit that hysteria has never been defined by the courts. It has just been noted that a person has shown a hysterical reaction, and in fact hysterical reactions often vary from individual to individual, and psychiatrists have noted that hysterical symptoms vary from individual to individual. Our learned opposition, our learned friends, stated that Schmidt's definition of hysteria showed exaggerated emotions. Therefore, one person's exaggerated emotions in a hysterical fashion may be widely different from other emotions that are exaggerated and that can vary. And we therefore submit that if such a vague and diffuse mental condition such as hysteria can be included in that definition of injury, then necessarily a easily and clinically diagnosed psychological condition such as acute stress disorder must also be included within that definition. My next submission, Your Honours, refers to other jurisdictions, and the fact that every other jurisdiction in Australia and also the United Kingdom refer to actual bodily harm as opposed to injury. If I may refer you to the Queen against Chan Fook, which was heard in 1994 in the second volume of the All England Reports at page 552, and also in the first volume of the Weekly Law Reports at page 689, Lord Justice Hobhouse stated in that case that actual bodily harm may include mental injury, but did not include emotions such as fear or panic, states of mind, or hysterical and nervous conditions. We submit, Your Honours, that
you're dividing line between mental injury and state of mind.
in this case, Your Honour, Lord Justice Hobhouse, and we do agree with this distinction, stated that states of mind can be confusing for a jury as they can refer to an unstable state of mind may not necessarily connote a psychological disorder, but a person may be feeling particularly emotional or distressed, but that was not necessarily a psychological disorder. He stated that if a psychological disorder was one, it should be stated as one, and that distinction should be drawn to allow flexibility between emotions and psychological disorders.
I recognise psychological disorder as distinct from transient emotional feeling.
Certainly, Your Honours, which can vary from individual to individual. We submit, Your Honours, that because of this case, we can see that in fact actual bodily harm and injury are different, as hysteria has been discluded from the definition in this case, and therefore injury can only be considered within a Victorian jurisdiction and with relation to Victorian Parliament's intention as opposed to regarding anything else in another jurisdiction.
There's no definition in other countries or states legislation which corresponds to our section 15.
No, Your Honour. The closest provision in other states to section 18, which we're concerned with today, is with reference to actual bodily harm, and in fact that legislation in other states in Australia does not actually define that in the legislation either, and it makes no reference to injury whatsoever in their Crimes Acts. Furthermore, I would like to refer this court to section 19 of the Crimes Act before 1985, which created the offence of malicious wounding. Malicious wounding plainly involves a a sense of physical injury. And we submit that the Victorian Parliament changed this provision to create Section 18 mentioning injury instead, to differentiate the two and to include mental injury within the ambit of that definition. We submit therefore that the inclusion of hysteria also in creating Section 18 makes it fundamentally plain that Parliament has intended to expand the definition to include mental injury. If I may move on to my final submission, Your Honours.
Before you do that,
Yes, Your Honour.
the law of the tort which relates to nervous shock being compensable, is this your hurt your argument?
Does it hurt our argument, Your
Does
Honour?
it assist your argument or hurt it?
Well, it has been held that nervous shock can constitute injury.
Yes, can you reason from that at all into this area?
Well, while we submit that decisions held in relation to different legislation is not necessarily comparable to the definition of injury with which we're concerned with today, we submit that nervous shock is just another, or it is another area which injury has been expanded to include.
Well, you say that the person, as a result of the sort of act that occurred here, received nervous shock, that would be within the definition of injury.
Yes, Your Honour.
Certainly be compensable at all.
Yes, Your Honour. Yes, because nervous shock could be diagnosed by a psychiatrist and is an acknowledged clinical psychiatric condition, therefore that would also come within the definition created by Section 15.
You say that assists your argument?
Yes, Your Honour.
Is nervous shock a diagnosable psychiatric condition, or is it really just an earlier, cruder version of what now the DSM-4 is called acute stress disorder?
Well, we submit that the two are separate. That nervous shock, while being diagnosable, is perhaps more like hysteria. It can vary from person to person, and different symptoms can vary in how visible they are to others.
So what I'm asking is, isn't nervous shock a legal fiction rather than a psychiatric diagnosis that was invented by judges administering the law of torts?
Yes, Your Honour, to clarify areas where it was difficult to comprehend whether, in fact, the victim did deserve some sort of compensation.
Yes, so if nervous shock is a legal concept rather than a psychiatric condition, isn't it really, as a legal concept, something that includes what we now see diagnosed with the benefit of the learning over 90 years in different psychiatric interventions in DSM-4 as acute stress disorder? I mean, wouldn't the symptoms of acute stress disorder also be symptoms of what we know legally as nervous shock?
Yes, Your Honour, I think that could be the case. Obviously, acute stress disorder is a very strictly defined within the psychiatric world. They have strict criteria, and therefore you either have acute stress disorder or you don't. But yes, certainly that could be found to be within the legal fiction, if you choose to call it that, of nervous shock, as nervous shock is acknowledged.
Well, if you forget about the tag from DSM-4 and just talk about the symptoms that were described, the symptoms that would fit within nervous shock, and would that then mean that was an injury?
Yes, Your Honour. Yes, Your Honour, they would. Certainly. The screaming and the trembling and the sort of unconsciousness and the vagueness suffered by Christine would certainly come in the ambit of nervous shock also.
The diagnosis of tag of acute stress disorder.
In relation to acute stress disorder? Well, we submit, Your Honours, that that being diagnosed with acute stress disorder, which has been written in a book by American psychiatrists, does not automatically show us that, in fact, it is a mental injury. We submit that Section 15's definition of injury is the main primary criteria by which we must assess injury and whether mental injury is a result. However, we submit that because acute stress disorder is an acknowledged, internationally recognised psychiatric disorder, and if psychiatric disorders are within that definition. I think it's both, Your Honour. We submit that it is a condition and yes, it will pass, but it is acknowledged as a disorder for the entire duration which the victim suffers from. Yes, if I may move on to my last submission, Your Honours. We submit that in the alternative that this court does not accept that acute stress disorder constitutes injury for the purposes of Section 18, we submit that Christine in fact suffered from hysteria in any case. No court has defined hysteria, as I previously mentioned, and has referred only to hysterical behaviour. We therefore submit that we could only judge her hysterical behaviour from what an ordinary person would take to be hysterical behaviour. And we submit that the references to her cowering on the floor, screaming, being unresponsive, staring blankly and trembling are all signs of a hysterical person. While it may not last for a very long period of time, and we submit that she was hysterical as a result of the appellant's reckless actions, and as a result it's still within the definition of injury as outlined in Section 15 for the purposes of Section 18 of the Crimes Act. Therefore, should it be held by this court that the learned trial judge did err in stating that acute stress disorder constituted injury, then there was no substantial miscarriage of justice as she came within the definition in any case, and therefore this appeal should be dismissed in accordance with Section 568, subsection 1 of the Crimes Act.
Thank you very much, Ms. Griffin. We're very late for the Law Council. Each of you performed that obligation. We'll retire now and we'll have to think to ourselves about these very difficult problems.
Commendable. All four speakers spoke very well, dealt with a problem which was very difficult, and dealt with it in a way which reflects the fundamental point, often enough forgotten by counsel, that it is to the legislation that you must go for the beginning, some of us would say the beginning and the end of the problem, not elsewhere. Now, all that being said, thank you for your participation. Thank you for allowing me to participate in it. The best individual speaker and the recipient of the John Phillips Advocacy Award, which it was intended he should present, was Junior Counsel for the respondent. For the winning team.
The President of the Court of Appeal. Oh, you want...
I wanted to take this opportunity to say thank you to everybody here. We're very fortunate to have a competition which is supported by the judiciary, the profession, the faculty, students and the community in general. The skills that are learned and the knowledge that is gained in this competition is invaluable, as I'm sure that all the competitors will attest to, and looking around the room seeing previous competitors and previous winners, I'm sure they will attest to that as well. Each year with the Moot competition, and this is my the 5th grand final that I've been fortunate enough to come to, each is unique in its own special way. And I'll never forget a number of years ago, Justice Hedigan saying to me that Mr. Omani, your argument was spoken like a true Irishman. The temptation to say to him that...
unintelligible.
The temptation to reply with it's the vibe of the thing, Your Honour, was overwhelming. As I'm sure watching the junior grand final this year, I'm sure everyone will be wondering whether the bench does believe that flirting is an everyday activity. But this sort of competition can't be run without the dedication of a number of organisers. Our organisers this evening, Caroline Cook and Nick Dragolovich, have worked since the start of the year in organising this competition, and the amount of work that they put in is extraordinary, and I'd like to hand over to them, but could you please join me in thanking them for their organisation.
First of all, I just want to say a couple of thank yous. First of all, I'd like to thank the competitors and congratulate the competitors, all the competitors that took part tonight, and they've had to go through a couple of rounds and quarterfinals and semi-finals, and I think they all deserve a round of applause for their achievement. Second of all, I'd like to thank all of our judges on behalf of coming. It's a great commitment. They obviously have quite significant workloads themselves, and for them to come out after hours and judge students and mooting really makes part of the competition what it is. It's a very important part, and we're very grateful for all our judges that have taken the time and been able to come out and take time from their commitments to come and judge tonight, so we'd also like to thank them.
And now we'd just like to invite the Honourable Justice Winicky, who is President of the Court of Appeal, to announce the winners of the Junior Moot.
Well, thank you very much. We too have had a very enjoyable night listening to those who have been participating in the junior final. Monash itself has a very proud history of mooting. And it's interesting when we look around the various law schools that we now have in Victoria to see that each has developed its own personality effectively, but Monash has been in the forefront of training people in a practical way. And mooting, of course, has been one of the ways in which they've achieved that. Tonight, I think, is probably the 3rd or 4th or 5th or 60th moot that I've had the pleasure to be present at, and it's difficult to tell you how impressive the people who have spent their time in preparing their arguments and presenting them to us have been. It seems to get better every year, but that's just probably a function of age on my part. But they were tonight very good indeed, and before we finally adjourn, I was moved to say to each of the people who appeared that they were very, very good individually and as teams, but that we would have to retire to consider our decision. And the final decision that we came to, that I was right. You were all very good. But in all these things, unfortunately, there has to be a winner. And it's my pleasure tonight to announce as the winner the appellants. Have we got the appellants team here? Are you going to take that? I am relieved of the prospect of telling you who the best mooter was. It's not something that I'd like to do, so I'll hand over to Mrs. Hample to do that.
I'd like to take credit for the best speaker, seeing I'm invited to give the introductory talk on preparation and presentation. having heard the quality of argument, I can only say it's notwithstanding what I told them that the quality of argument has been so good. And I am absolutely delighted to say that in a very close field, the best speaker is Junior Counsel for the Appellant, Tanika Spencer.
Thank you very much. Once again, please join me in thanking all the competitors in the senior and junior competitions. And finally, just before, actually we'll give one more round of applause for the judges as we give them their gifts.
Thanks, Nick. It was a pleasure.
And last of all, I'd just like to make a mention of our wonderful sponsors, Dunhill, Madden Butler, who have sponsored us for many years in the mooting competition, and who, without their support, we wouldn't be able to put on such a good, or such a number of rounds, and have dinners and presentation ceremonies and things like that. And we're very grateful for their support over not just this year but years in the past, and we're sincerely grateful for their contribution.
That ends the formality.
Thank you very much.